And talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt Law or interact with the show by sending an email to ask@DeWittLaw.com, or you can also call 407-53-MOSES. Every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host and expert, Moe DeWitt of the DeWitt Law Firm. Moe will answer your questions to discuss the latest legal issues affecting the citizens of Central Florida. All right, Moe, here we are, another Sunday, and we've got some great listener interaction this weekend, this Sunday,
which we love.
Yeah, we've got some really, really good questions that we're going to get to this morning. So let's go ahead and recap kind of what we've been talking about, at least the last month or longer, about the legislative session and what's going on with that, and any updates you have for us.
Yeah, well, there's been a lot of stuff in the Florida legislative session this year, which we also had an extended session that we've really been following for the listeners because they really affect the people of Florida. Mm-hmm. Two big areas specifically that we've been following, at least, and one is the Alimony Reform bill, which, as we've talked about before, it's been in the Florida legislature, our Florida legislative session, at least a few times. I think this was the third time they tried to get it passed, and it did pass both the House and the Senate. I can't talk today.
Yeah, you're good.
Passed the House and the Senate, but ultimately was vetoed by the governor. So we're waiting to see if he was going to veto it. Governor DeSantis did veto it. And the reason he vetoed it, I'm not speculating here, he actually put this in the letter, was that he thought the retroactive aspect of the bill was unconstitutional.
Okay.
And so, that was the issue, the concern that we brought up from the very, very beginning was, hey, if this bill is going to pass, there's two provisions it's probably not going to have. Number one, the retroactive aspect, because that's the most controversial aspect. And number two, the 50-50 presumption for child time sharing or custody.
Right.
Of course, they put both of those aspects in the bill. And so, Governor DeSantis basically said, based on my information and knowledge, and, he has a legal background, obviously, he believed it to be unconstitutional. So he believed it would be best to veto it because ultimately, if he didn't, it would be challenged in the courts. It would probably be found unconstitutional because the problem is when you retroactively go back and you modify contracts, because when you get a divorce, if you enter into a marital settlement agreement, that agreement is a contract.
Right. Okay.
And so under the Florida Constitution, we have the right to enter into contracts, and we have the right for the state not to interfere in those contracts. So when you have a bill that's passed that retroactively goes back and modifies those contracts basically unilaterally, it could be declared unconstitutional. And so that's the real concern with that provision. Now, we've seen that provision go into the bill either 2 out of the 3 times, or I think it was 2 out of 3 times now. Might have been 3 out of 3. So obviously the legislature wants this to be retroactive, and I'm sure that there's some, the people who are paying alimony, of course, want it to affect them. Right. They want it to impact them. They want to stop paying alimony. But, as the governor said, it's probably going to be unconstitutional, even if it gets passed, even if he didn't veto it. Once it got to the courts, and went up through the court system, went up on appeal, probably ultimately we get to the Florida Supreme Court, they would probably find it to be unconstitutional, and then you just have a big mess on your hands and have to start all over anyway. So it'd be a big waste of time, big waste of money. So ultimately he vetoed that. I know a lot of people are happy about it, a lot of people are unhappy about it, depending which side of the fence you're on. But that's what happened. So we're back to square one. No alimony reform, as we've talked about before. That alimony probably does need to be reformed. It's just a matter of putting together a bill that actually works. And, sometimes I kind of wonder, the people in the legislature can't be stupid. They must know, they must have information that this is going to be unconstitutional. So I always kind of wonder, is there a game? Is there an element here where they put this in so they can say, oh, I support the alimony reform bill, yada, yada, knowing that it's ultimately going to get vetoed because they put the retroactive aspect in there, or knowing that's going to be determined to be unenforceable. So I don't know if that's going on, but, as we've said from day one, if this ever really wants to get passed, they need to get down to business and actually pass a bill that's not going to be retroactive, because no matter what happens, I think it's going to be very difficult for that to be upheld.
So third time was not a charm, and here we go back to the drawing board.
Back to the drawing board. We'll see if it comes back up next year or if they wait a couple of years.
Okay.
And the interesting thing with this, when it came through this year, was they kind of had a bill that I think really would have worked in the beginning. It had, for the first time ever, and had the support of the Florida Bar Family Law section. Basically, the family law attorneys from the Florida Bar supported it.
Okay.
That was the first time ever that the Alimony Reform bill had their support. They had this bill that kind of worked, frankly. And then sort of as the days went by, kind of at the last minute, they just overhauled the bill, completely changed it, put both of the controversial provisions in it, and passed it. So, maybe had they stuck to the original bill, it would have actually worked. Of course, we never know what's going on behind the scenes. We can only speculate.
Right.
But ultimately, I think the big disappointment here is, as the legislators are supposed to kind of help the people. And when they do this kind of stuff, when they put together a bill that just doesn't work, that's unconstitutional
Three times,
that's going to either get vetoed or overturned by the courts, it's just a big waste of time.
Right.
Doesn't help anybody. So hopefully, if it's introduced in the next session or the session after, hopefully they can put together a bill that has the support of the Florida Bar Family Law section, which if they do, I'm not saying that the Florida Bar Family Law section is, the be all, end all,
right.
no, but they're not going to support a bill that's unconstitutional. They're lawyers. They're going to look at a bill and say, okay, how is this going to affect the courts? They're the people who deal with these kinds of cases every day.
Sure.
So they do have some intimate knowledge. And that's why typically, when you're creating these bills, obviously legislators don't have knowledge of everything. Nobody can, right? So that's why you have to consult these types of sections, these types of experts to get the information when you're trying to draft the bill to make sure the bill actually works. So we shall see.
All right. Before we get to one of our questions, you want to kind of do a little summary, little recap on what we've also been talking about with the insurance.
Yeah, that would be great. So, huge issue this year in the Florida legislature, and that's why we had the special session, was, of course, this issue we've been having with homeowners insurance in the state of Florida. Tons and tons of problems. Insurance companies pulling out of the state left and right. Policies being canceled. I had my policy canceled. I'm sure tons of listeners out there have had their policies canceled.
Several friends, coworkers, everybody, same boat.
Yeah, actually, this morning I got somehow a buddy of mine, his insurance adjuster sent me his new policy because he got canceled, I guess. I had to forward along to him and say, I think they sent this to the wrong place. But anyways, so they've been trying to address this, trying to get insurance companies to come back to the state of Florida, because basically everybody in the state is having to switch to Citizens. And last we checked, Citizens Insurance, which is the state-backed insurance fund. A lot of people don't realize that. They think Citizens is a private company. It's not. It's called Citizens because it's backed by the citizens of Florida.
It's who I have.
Yeah.
I had no idea.
Yeah, and so they were signing up 5,500 new policies a week.
Unbelievable.
In the state. So obviously, when they're state-backed, they just can't support.
Mm-hmm.
They can't support everybody in the state of Florida. That's not diversification. That's not the way insurance works, frankly.
Right.
So, the governor and the Florida legislature are trying to do things to make it more attractive to come back into the state of Florida. They passed some reform. Ultimately, what I'm hearing from insurance agents out there is they don't think it's really going to do much. Rates are not going down. But the one big thing that it did do is the insurance companies can no longer cancel you unless just for your roof, basically. So what they were doing before, let me back up, is when your roof got to 10 years of age, and this is why I got canceled, they were automatically canceling your policy.
Right.
Basically saying either get a new roof or we're canceling you. And so this new bill basically said they can't do that solely based on the age of your roof until it gets to 15 years. So it bought you an extra 5 years. Now they did some other things where they did this reinsurance fund and they did a bunch of other stuff to try to get insurance companies to come back to the state of Florida. They said it was going to lower premiums. Debatable. Frankly, I just had to get new insurance. Premiums didn't go down.
Neither did mine.
Yeah.
I had brand new roof. I'm thinking for sure. I'm like, nice. I'm going to save some money now. And
right. You would think with a brand new roof. Yep. And it's just not happening. The premiums, or excuse me, the premiums are not going down, and the deductibles have gone up substantially.
Big time. Yeah.
So if you look at the new policies now, typically are now under this new legislation, rather, under the new policy, the deductible is going to be 2% of the value of the policy.
Okay.
Or if for a roof can claim 50% of the cost of the roof, essentially.
Okay.
So check those deductibles. Make sure you're aware of what your deductible is on your policy when you renew. Now, you may be able to negotiate other deductibles. It may just affect your premium. So, just have an informed conversation with your insurance agent. I think that's the biggest takeaway from this legislation is when you get your quotes back from your insurance agent, give them a call and ask them to walk you through it. Say, what is my deductible on this? If something happens to my roof, if there's a hurricane, what am I obligated for, right? Because you want to make sure that there's no surprises.
I think a lot of people have no clue, and then all of a sudden that mouth drops open when they find out, like, okay, this happened, but wait, I'm going to be how much out of pocket?
Right. And the scary thing is, something happens and then you don't have the money to do it. So now you're either living in a house that's crumbling,
right,
doesn't have a roof, there's water coming through the ceiling,
the blue tarps,
and there's nothing you can do because you don't have the $20,000 or $50,000 to put up to get a new roof or get the thing fixed or whatever it needs to do. So just be aware, what is my deductible? What is if there's a hurricane? What is if I need a new roof? Talk to your insurance agent about that. Make sure you know what it is and that you're prepared for that. Because ultimately, a lot of times people are shopping based on those monthly premiums. I get it. You want that to be as low as possible, but you also don't want to put yourself in a situation of peril, essentially, where your whole house could be destroyed because you can't afford to fix it. And now it's full of mold and everything else, and you have to move out and the thing has to be demolished.
And then can you get canceled because you don't fix it? Can an insurance company come back and be like, hey, you didn't end up fixing this, so now we're not going to carry you anymore?
Yeah,
is that possible?
Eventually they'll cancel you because you can't fix they're not going to insure a home that has a giant hole in the roof.
Yeah, right.
So that's obviously going to be a problem. And then, what do? Do you let the house go into foreclosure? I mean, it can really cause financial ruin when you're not aware of these things.
Just to save a little bit on your monthly premium. So good advice.
Yeah. So definitely be checking that, be talking to your insurance agent, have an informed conversation. Just make sure you know what your deductibles are under every situation.
Gotcha. All right, we got a couple minutes left here, but speaking of roofs and damage and things like that, let's get to our first question. They want to know, have huge old oak trees in our front yard and have a lot of branches that overhang the road. It's just a small road. They said they once filmed a commercial for an allergy medication on the road because they had so many tree canopies.
That's pretty cool.
They said, my question is, if a limb from our tree fell into the road and damaged a vehicle or somebody walking, riding a bike, would they be liable, or should the county be responsible for trimming these tree limbs?
So typically, if the tree limb is overhanging a property line, for instance, if that tree limb were to fall into their property line, whoever's property it is responsible for the tree limb.
Okay.
The only exception to that is if the person knew that it was a dead tree and was going to fall and didn't take any action. So if the tree limb were to fall on the county road, the county would be responsible for that.
Okay.
Now, if the tree limb were to fall on a car and hurt somebody, typically still the county would be responsible unless you can show that the property owner knew that the tree was dying and didn't take any action.
You're just being negligent and
you're being
ignoring
negligent,
it.
exactly.
Okay.
So otherwise, always, first of all, make sure it actually is a county road, not a private road, not part of HOA. And you should still obviously trim up the tree and keep it in good condition and make sure it's not dying, get an arborist out there. But typically, if it's overhanging a property line, it's that person's property, or that person who is responsible for the maintenance.
So even though that trunk is in your yard.
Yep.
Because I just learned something new. I remember somebody telling me, like, well, it's in your airspace or my airspace. And I'm like, what are you talking about? And I always assume, because I have a yard that is full of slanted oak trees, but they're solid, knock on wood for right now, as we're in hurricane season. And I always wonder, if it were to fall on like my neighbor's house or hit their roof or something, I would be responsible for that, but not necessarily.
Right. Unless you knew the tree was dying or dead.
Yeah.
If it's overhanging their property, they're responsible to trim it back away from their roof.
Interesting.
Yeah.
I just learned something new.
Yeah. And that's why a lot of times when, you get your trees trimmed, a lot of times neighbors will get together and say, hey, you want to trim back the side that's on your side of the property. You pay for that. I'll pay for the side on mine. They're coming out here. Typically, you can kind of get a cheaper rate when you do that.
Right.
And get it taken care of and make sure there's no issues in the future.
Perfect. Great advice. Great question, R. Newman. I don't know if it's Mr. or Mrs. Newman, but R. Newman. So thank you for your question. Got more questions coming up, then we'll get to yours as well. And if you've got your own question, you can always participate on the show by sending it to ask@DeWittLaw.com. That's ASK, ask@DeWittLaw.com. You can also call 407-53-MOSES. You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. More with Moe DeWitt coming up in just a few minutes on WDBO.
I had stopped, and for some reason I look up and I see the headlights coming up, and I knew he wasn't going to stop. I'm just sitting there bracing for it, and sure enough, bam. And a couple days later, I woke up and said, oh no, my neck was hurting, back is hurting. And I felt hopeless. I didn't know what to do because I thought it was over. Maybe in that moment, was I supposed to call someone? At this point, is it too late? And I went on the internet. First thing that pops up is DeWitt. And I said, okay, I'll give him a call. We'll see what happens. I don't know about lawyers because I was the same person. I was afraid of it, to be honest. I thought maybe I'd have to pay them if I lost. Like I just didn't know how it worked. I think the biggest thing that I can say that DeWitt helped me with was holding my hand through the process of treatment. They actually were able to refer doctors to go to. I got help with my MRIs, with all the scans we had to do on the neck. So there was so much that goes into a car crash process that I truly just didn't know. If you've been hit, call. Simple as that. Because you don't have to do it alone. There's people like the DeWitt Law Firm that will help. If you're injured on the go, just call Moe.
Hey, thanks so much for listening. It's the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. My name is Jay Edwards here with your host, Moe DeWitt. If you've got a question and you want to get involved with the show and you want some legal advice, you can email us at ask@dewitlaw.com or by calling 407-53-MOSES. Every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host and expert, Moe DeWitt of the DeWitt Law Firm. And speaking of people getting involved, we've got some more great questions. So here's one for you, Moe. They want to know, can my soon-to-be ex-wife come after my house? Said they dated for 4 years, married for only 4 months. Says he bought the house prior to them getting married. Her name is not on the paperwork, and I'm just wondering, will I have to fight her in trying to keep her from getting my house or part of its current worth?
So the house is obviously premarital, right? So she doesn't have a right to the home. However, and in this case, it's a short-term marriage. So the short answer is no, but let me explain why, essentially. Okay. So in Florida, even if you have a premarital home, if you're married for an extended period of time, the spouse can still be entitled to any increase in value of the home, whether that increase in value is from paying down the mortgage on the home or just from passive appreciation, the home increasing in value over time.
Like right now, how high?
Yeah, which could be a roller coaster, but we'll see.
Right.
So there's what we call the CAW formula in Florida. So basically that's when you're dealing with non-marital property,
right, and
then you have to figure out what the increase in equity essentially is in that property. Now here, given that it was a 4-month marriage, there's probably not going to be, it's going to be de minimis, whatever the increase in value is, most likely. So it's going to be very difficult for somebody to make a claim in a 4-month marriage like this. But if you have a 4-year or 5-year marriage, depending on what the market's done, how much the mortgage has been paid down, there could still be a marital component to it, even though it's a non-marital property. And that's where people need to be very careful is, a lot of times people say, oh, I haven't, the property was purchased prior to the marriage. I don't need a prenuptial agreement. We'll be fine, yada, yada.
Right.
That's where, a prenuptial agreement will really help you because it eliminates those kinds of arguments. If your intent when you get married is you keep what's yours, I keep what's mine, maybe you both have premarital properties. But of course, if a divorce occurs, things go sour and go south, and people may not still have the same belief of you keep what's yours and I keep what's mine, and we go on our merry way.
How things can change in 4 months, right?
Yeah, exactly. So that's where a prenuptial agreement comes into play. But typically on a short-term marriage like this, while they could still argue it, I think it's a very tough argument to make just because it's such a short-term marriage. But it's something for people to be aware of. Anytime you have premarital property like that, even though it's premarital, even though it's held solely in your name, if you've been married for an extended period of time, the values have changed, the mortgage has been paid down. Every situation is different, of course. Rental properties are different than a marital home and so on and so forth. But there can be a marital component. There can be an argument made for that. It's a Florida Supreme Court case called CAW. That's why it's called the CAW formula, KAAA versus KAAA, CAW versus CAW. And so if you ever wanted to do some light reading before bed, you could read that and that would tell you more about it. But that's essentially what it says. So yeah, be careful out there. If you do have premarital property and you're getting married, always a good idea to consult with an attorney, whether it's me or somebody else. Know what your options are, know what your rights are. And while it may be uncomfortable, a lot of times if your intent is you keep what's yours and I keep what's mine, a prenuptial agreement can be a good idea, protects both parties, And really just if things do go south, if a divorce does come down the road in the future, it just makes the whole process a lot easier.
Well, not saying that, this is what happened in this situation, but I'm sure there have been situations where that's the other person's intent. I'm going to marry you. I'm going to get a piece of this big old house right here. And so to have that prenup or whatever, and luckily it was only 4 months, so maybe they wouldn't get very much, but they might get some.
Yeah, and it may not be their intent, but of course, once you're no longer in love, you may get a little, you might be a little sour and a little devious, and a little bitter, and basically say, I'm going to get whatever I can, right? So that may be their intent once they're going through the divorce process. They just say, I don't care anymore. I'm going to get whatever I can. Mm-hmm. And then they start looking under what their legal rights are, and they say, okay, well, there's this call formula here. You may have only been married 4 months, but we could still make an argument for it. It's going to be a tough argument, but they may just, again, make the argument to see what they can get out of it. Right. That can make things very difficult. Okay. So that's where a prenuptial agreement is very helpful. And of course, when everyone's on good terms, that's the best time to negotiate.
Absolutely.
Rather than when everyone's bitter.
Yep. All right. It's a great question. Thank you. More of your questions coming up. You're listening to the DeWitt Law Review on 107.3 FM and AM 580. If you've got your question, ask at DeWittLaw.com. You can call it in as well. You've got 407-53 Moses. And if you ever need any help, any legal advice, you can call the office anytime at 1-800-DeWitt Law. That's 1-800-DeWitt Law. It's the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
About a year ago, I was in a really bad accident. I got my hand caught in a saw and I lost my thumb. Luckily, the doctors were able to put everything back together. Originally, we reached out to other firms to take my case and nobody would help us. But when we called Mr. DeWitt and his team, they were there to help through the whole thing. I'm extremely happy with the result. Extremely happy with the result. It was an easy process. They made it as easy as possible, and we got the best possible result. Injured on the go? Just call Moe.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards. If you need some legal advice, this is the guy you want to call, Moe DeWitt of the DeWitt Law Firm. Moe, how can people get in touch with you and your team, or if they have a question, if they need legal advice, what's the best way?
Absolutely. So you can always check us out online, DeWittLaw.com, DEWITT law.com, or give us a call. We have people standing by basically 24 hours a day. 1-800-DeWitt-Law, 1-800-339-4885. Always happy to help any way we can. And if it's not something that we can assist you with, we'll try to get you into the right hands of somebody who can assist you. So obviously, we don't do every area of law, but usually we have a partner or a relationship or know somebody who might be able to assist you with that. So we'll always try to get you over there. And of course, if you ever have legal questions, that's what we're here for every Sunday. Always email us, ask@DeWittLaw.com. Happy to give you a little free legal advice on the air here. That's what the show's all about. And hopefully, sometimes people don't want to have to talk to an attorney. It's just a simple question, or maybe you're just in the beginning of the process and trying to learn a little something. And that's what this show is all about, is trying to inform people, educate people on topics. The law and dealing with lawyers is such a scary thing for people. Most people
intimidated.
It's intimidating. Mm-hmm. Exactly. They don't want to talk to lawyers. I always say, I wish we were in the business of selling pizzas, because everybody's happy to see the pizza guy. Nobody's ever happy to see me.
Unless you have a pizza.
maybe we should free pizza with every consultation. No, we're not doing that. That's not a real promotion.
No.
But so that's the whole point of this show. We're trying to make it easy, easy access to get some legal advice just by emailing us, leaving a voicemail if you want on the voicemail line, which is 407-53 Moses or 407-536-6737. That way, because a lot of times people don't need a full consultation. They don't want to sit down with an attorney. They're just trying to learn a little bit of something or try to get pointed in the right direction.
Right.
And that's what we're here for. So like I said, always feel free to email us, ask@DeWittLaw.com. But if you do need to get a hold of us, if you do need help with a divorce or a car accident or a family law issue, 1-800-DeWitt-Law, 1-800-339-4885. That's what we're here for, and we'll try to help you out.
That's your way of giving back to the Central Florida community as well. It's an awesome thing that you guys do.
Well, it's fun. It's fun for us.
Right.
That's
all right.
That's the fun part of our job.
Let's get to this question. This comes from Janine. She says that my mom just went to a rehab facility and they want us to sign an in-house arbitration agreement. I haven't signed it. That is basically saying I have no legal recourse if something happened to her. Is that correct?
So no, that's not correct.
Okay.
So first, to kind of understand that, you'd have to understand what arbitration is. And I think a lot of times people get that confused, or they really don't know what arbitration is. So arbitration is basically a private court system. So you're waiving your right to a jury trial, and you're waiving your right to take your case in front of a judge. But what you're saying is you're going to bring your case to an arbitrator. Sometimes it's a one-panel arbitrator, meaning one person. Sometimes it's a three-panel arbitrator, meaning three people.
Okay.
And usually they may be former judges, or they may be lawyers in that field, or some sort of expertise in that area regarding whatever the claim may be.
Right.
So in this case, if it was a rehab facility, they probably have some background in, medical malpractice or negligence, or, whatever it may be. Because even though it's a rehab facility, it could still cover if it was a slip and fall at the facility, if it was a billing dispute at the facility. Typically it can cover basically anything that happens between her mother and that facility.
I got you.
Would go to arbitration.
Okay.
So you're not waiving all your legal rights. You're just saying you're going to take it to this arbitrator to determine what you're entitled to. So instead of filing a lawsuit in court, what you typically do is you send a notice of arbitration to the facility, and that starts the claim. And so it's basically like a private court system. Now, it's important to know that typically arbitration is more defendant friendly, right? It's not going to a jury of your peers. It's going to one individual. So typically, it's deemed to kind of be more defendant friendly because they usually give lower verdicts. It's usually more defendant friendly and more facility friendly, and that's why they use them.
Right.
Arguably, it's also less expensive than going to trial, than having a full-blown trial. So, but it does significantly limit your rights because you can't go to court. You can't take it and file it in a local court here and go have a jury trial. You're waiving that right.
So once a judgment comes in or a decision is made and you're not happy with it, you then can't go and say, well, forget that. I want to take this to a court, to a judge. Is that something that
No.
you can do? No.
Once it goes to arbitration, once they determine it, in most cases, that's the final
That's
say.
it.
So usually you're also probably waiving your right to any appeal from there as well. Now,
Okay.
it depends on the terms of arbitration, but usually you're waiving your right to appeal. Now, and it depends on your side. Sometimes arbitration can be very beneficial, but in most cases, in a situation like this, it's probably not consumer friendly, if that makes sense.
Right.
But that being said, if you want to do business with them, they have a right to contract, and most of these rehab facilities are going to put an arbitration provision in their contract. When you buy a car, most car dealerships have an arbitration provision in the contract. Now, nobody ever reads these contracts.
That's the sign here.
Yeah. Someone actually read it here and had a question about it. But yeah, usually you're limiting yourself in these contracts to arbitration. It's not the end of the world, meaning you don't have any rights, but it does potentially limit your rights, essentially.
So if she said no to this, chances are the rehab facility could refuse service to her mom?
Absolutely. So most facilities will. They just basically say, this is our standard agreement, take it or leave it. You can try to negotiate with them. So I actually took a class in law school on mediation and arbitration. It was taught by Justice Polston, who's on the Florida Supreme Court. And he was actually appointed to the Florida Supreme Court during the course, which was kind of neat.
That was kind of cool.
Yeah.
Cool week at school.
We got to go to his investiture. I mean, he's a very nice guy. But he would tell stories that he would always kind of have fun whenever he would go to buy a car for one of his kids or for himself. He would always try to negotiate out the arbitration provision and see if anyone would ever let him do it, because it was just kind of fun for him. And I don't think anyone ever really let him do it. Most people didn't even know what he was talking about.
Right.
You're talking to the sales guy at the car dealership.
Hey, let me get my general manager.
Yeah, they're just like, I just want to make a sale here, sir. What are you talking about? But yeah, typically they'll just say, hey, this is our contract. We can't negotiate on it. We can't remove it for you. If you're not comfortable with it, go somewhere else. But, especially with these medical facilities where they are, could be subject to a lot of negligence claims, medical malpractice claims, all that kind of stuff. A lot of them have gone to these arbitration provisions. Now, there's still certain cases where the arbitration provision may not be enforceable. That's a course for a different day. We'll have to get a 6-hour block to talk about that. But, just assume if you're entering into a contract here, it's probably going to be enforceable, and you're probably going to be limited to arbitration, and you're not going to be able to take your case to court.
So it's fairly common. They're not asking you to do something out of the complete ordinary.
No, I think most sophisticated businesses now have included arbitration provisions in their contracts when you're dealing with them. So yeah, typically you're going to be kind of stuck with it.
All right, Janine, hopefully that helps. Again, if you have your own question, you need some legal advice, you are more than welcome to go ahead and send it over here to us ask@DeWittLaw.com, or you can also leave a voicemail at 407-53-MOSES, 407-53-MOSES. And if we can't get to it today, maybe we can get to it next weekend and help you out with a little bit of advice there. All right, this one sounds like it's coming more from a younger individual, like a child, not necessarily a kid, but they want to know, my stepmom, a minor is what I should say, my stepmom legally adopted me when she and my dad got married, but now they're getting a divorce, and she wants to know, do I have a say in where I live, since legally she's my mom, or will that be up to the judge or my dad to decide?
So even though you're adopted by the step parent, you're still legally the child of that step parent. So it's going to be no different than any other normal divorce. And in any divorce, basically the statute does say that the child's preference can be taken into account based on the child's age and maturity and things like that. And I always use the example of, you're not going to give a 10-year-old the option of picking which parent to go with, because they'll go with whichever parent gives them more candy, right?
Of course. I still would do that today.
Well, yeah, me too. So typically, judges really, in my experience at least, really don't rely too much on the preference of the child. In very limited circumstances do they look at that. And typically children are really not supposed to be involved in the divorce process. So again, in very limited circumstances, is the judge going to allow a child to testify in court? And even if they do allow that, typically it's going to be just the judge and the child and a court reporter in private. There's not going to be attorneys there. The parents aren't going to be there for kind of obvious reasons. You don't want to put the child through that kind of pressure, things like that. So typically it's going to follow the normal divorce process. Now, of course, the court still has to look at the best interest factors, what's in the best interest of that child. What kind of relationship did they have with the step parent? How long has the step parent been in the child's life? How involved is the step parent? All the factors that are listed in the statute to determine what's in the child's best interest.
Right.
But it's important to know, when you do a step parent adoption like this, you step into the shoes of a parent legally and fully. So you're obligated for child support. You're on the hook.
Really?
Absolutely. So, the step parent can't get out of child support unless the other parent agrees to terminate the parental rights, which is can be very difficult, if not impossible.
Right.
It's a whole different conversation. But yeah, we've had cases before. And one that pops into my mind is a case where the dad adopted 3 of the children that the mother had from a prior relationship, and the 3 kids would not speak to him. I mean, he had no contact with them basically since they separated. Divorce. It was a very contentious divorce. Took about 3-4 years. Wouldn't speak to him at all. He was on the hook for child support the entire time, even after the divorce. Wouldn't speak to them, and he had to pay child support until those kids aged out because he legally adopted them. So that's something you want to be aware of.
Wow.
It is a commitment. It's not just, hey, I'm here while we're
sweet thing to
married.
do, right?
Right.
Yeah.
It's a commitment down the road. While you may have time sharing. Hopefully you have a relationship with the child afterwards. In this case, the dad didn't. The kids sided with mom, and there was obviously issues there that they were going to divorce. But he was still on the hook for child support, and that's just the way the law is. There's really no way around that. So just something to be aware of. This is a very serious legal commitment. You're stepping in and saying, I'm going to be the parent of this child. Just because it's an adoption, just because it's a step parent adoption, doesn't mean you have any less legal rights than a full-blown parent. So you got to take the good with the bad there.
So basically, she's not going to, it sounds like she's not going to have a whole lot of say in this. This is going to be for the judge to do a lot of interviewing, a lot of question asking between the stepmom, the dad, her natural dad, and maybe a little bit of her.
Yeah, I mean, typically, like I said, courts, they'd really like the child not to know anything that's going on in the divorce. That may be a little idealistic, but typically, kid would obviously know that there's a divorce going on, but beyond that, really not know what's going on. And then the court would, look at each parent, look at their witnesses, and try to make a determination as to what's in the best interest of the child if the parents can't agree, and come up with a parenting plan on their own. And I've said it before, I'll say it again, obviously the parents are going to know what's best for the child if they're able to act, how do I put this? If they can kind of cooperate together. Which a lot of people, if they can act cordially, if they can cooperate together, a lot of people can't do that. But if they can do that, obviously they're really the best judge of knowing what's in the best interest of the child. If they can't, then it's going to go to a judge who's going to make a determination after hearing evidence, from 4 hours or 8 hours, 1 or 2 days typically. And they're going to make a decision based on a snapshot of what they see.
Mm-hmm.
And oftentimes, nobody's happy with that decision because it's not what either party wanted. And it's not always in the middle either. It could be something completely different. And so you have to live with it. You're stuck with it once it happens. So, time sharing custody cases are very difficult because ultimately, really nobody's happy. But you're trying to do something that's in the best interest of the child. And if you keep that in your mind that, hey, I really want to do what I truly believe is in the best interest of the child, I think that's how you get the best result, meaning it's the easiest result to live with for the rest of your child's, minor life until they age out, essentially.
Well, and, I think it's probably hard for some people to do that when you're bitter or,
Absolutely.
Somebody stepped out in the marriage or something like that. And, I don't want to see you happy at all, even if it involves the child. And sometimes, like you said, you have to move past that and put the kid first. If stepmom is an amazing, role model to this child, and this child adores the stepmom, then let the kid have some time with stepmom.
Yeah, I think sometimes, though, it just becomes very difficult to process that you're not going to see your child every day.
Right.
I think that's very, when you go through a divorce and you have a child together, whether it's a step-parent adoption or not, going from the situation of you get to see your child every day to, even if it's equal time sharing, 50-50 or whatever it may be, I think it can just be tough to imagine that. I mean, it's a huge change in your life.
Definitely.
And it can be very difficult, especially if you have a younger child, to go, days or weeks without seeing them.
Yeah, especially when things like birthdays and holidays come up. He's like, what do you mean I'm not going to see my kid on the 4th of July or something like that?
And that's why it's important to really do a good parenting plan that's very specific, that goes through all of those situations. And, I've had people in divorces before come in and say, oh, we don't need a parenting plan. We'll figure it out. Well, that's great until it doesn't work.
Right.
Because, you may get remarried, you may get a new girlfriend, boyfriend, whatever it may be, and that person may not be happy with what you guys had agreed to before.
Mm-hmm.
So what I always say is, even if you're on the best of terms during the divorce, you think you can agree upon everything, sit down and do a really detailed parenting plan of what you guys agree with. Then take that parenting plan, shove it in a drawer. Hopefully you never need to look at it again.
Right.
But if there's a disagreement, that parenting plan controls. And so you can go pull it out and say, all right, we can't agree on this. This is what happens under this situation. And that will save you so many headaches down the road, so many trips back to court. Because when people do these kind of, fluff parenting plans, or they're just going to agree upon everything, or they're not really detailed, that's when they get into the issues. And I've seen it 1,000 times. And I'm sure there's somebody out there saying, oh, I did that. It's not going to happen to me, yada, yada.
Right.
I've seen the horror stories. I know what's going to happen. There's going to be some change in your life, and something's going to happen, and you're going to wind up back in court, and you're going to be litigating this. It's going to cost you tens of thousands of dollars and a year or two of your life that you don't want to have to deal with.
Gotcha. That's some good advice. All right. Thank you, Mo. And more great advice coming up in just a few minutes. It is the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
So I want to show you something. Here, come closer. See this letter here? This letter offered for our client to settle for $10,000 back in May of 2021. We just got this client $200,000 for that same accident. He didn't want to take the $10,000, and rightfully so, because the insurance company was offering him pennies on the dollar. Oftentimes, clients get impatient, but in this case, it was worth the wait and worth to fight the insurance company to get what he deserved. Injured on the go? Just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. We got to spend the hour with your host and expert, Moe DeWitt of the DeWitt Law Firm. Mo's answering your questions, discussing the latest legal issues affecting the citizens right here in Central Florida. Have your own question? Ask at DeWittLaw.com, or you can call 407-53-MOSES. And if you need help anytime, they're standing by. They can help you out right here at the DeWitt Law Firm if you just call 1-800-DeWitt-LAW, 1-800-DEWITT-LAW. All right, Mo, here we go. We got the Mo Pro Tip of the Week. What do you have for us?
So this one I have to give credit to Todd Ulrich over at WFTV, because I saw his tip and I started looking into it. I go, that's a really good tip. So I'm going to steal it, but I'm going to steal it with credit to him, because he deserves the credit. But given that everyone's, getting back into travel mode, we're flying all the time, we've seen all the issues with the flights being canceled out there. Todd pointed out, under the U.S. Department of Transportation, they give passengers actual rights if your flight is canceled. And so if your flight is canceled and you choose not to travel, you are entitled to a full refund. And you can actually see your rights by going, just Google U.S. Department of Transportation airline refund policy. It will come up. And not only are you entitled to a full refund if your flight is canceled and you choose not to travel, but if there's a schedule change or a significant delay and you choose not to travel, you're still entitled to a full refund. So a lot of times they may try to rebook you on a different flight.
Right.
Maybe that doesn't work for you. You don't just want a credit, cite to this and say, hey, I would like a full refund. And you can pull it right up and show it to them. Because obviously, not saying the airlines are bad, but just like any other business, I'm sure they don't want to hand out refunds all the time.
Of course, right.
And sometimes you may have to point out to them that you do have legal rights. And if they can't perform under the contract, meaning they fully cancel the flight, they delay it, they bump you, they move the date, the time, it's a significant delay, then you are entitled to a full refund. You also, if they change your class of service, let's say you had a first class ticket and they bump you down to a economy class,
right,
you're entitled to a refund of the difference, not just an airline credit. And that's what they often try to give you.
So they're not handing out cash.
Exactly. And I don't know if you're like me, but I've had airlines hand me like a paper ticket airline credit before. God knows where that thing
you
went.
lose it. No, you do. You try to put it someplace safe and then you forget where you put it.
Right. And then you have to remember when you're rebooking on that same airline and all this
stipulations and everything. It can only be Monday through Thursday. And it's like, wait, what?
Right. So, I mean, and there's also rules regarding baggage fees, if you're entitled to a refund of the baggage fee. So it's just a good thing to kind of have in your back pocket, especially considering what's going on there in the travel world right now. Lots of flights being canceled, lots of flights being delayed. Hey, maybe if they're going to bump you to the next day, you can get a different flight on a different airline, and just ask for a refund. It might be more convenient for you. So just know that when you're traveling. So again, I'll give Todd Ulrich over at WFTV some credit for this one. But, like I said, it's transportation.gov, U.S. Department of Transportation airline refund policy. It lays out your rights right there. Easy to pull up on your phone if you run into an issue, and show the person at the counter there, hey, you got to give me my money back.
I want to see their face when I pull this out, and because they're going to be like, "Wait, nobody ever argues this," But it's right there, it's laid out.
And I wonder if it's one of those things where they know it, and then once you show it to them, they go, "Oh, all right,
you're one of those
people, huh?"
But I mean, it just helps to know, and I mean that's what the whole point of of your pro tip of the week is, because I never knew that. I figured you just suck it up and you deal with it.
Yeah, I mean, I've run into this issue before, and I've taken the airline credit, which I've never used. And, obviously I was entitled to a refund had I just asked for it. So
you got to find that certificate now. Yeah. It's buried somewhere.
Dig through my entire house for the next month, see if I can find it.
Right. All right. Well, you've been listening to the DeWitt Law Review on 107.3 FM and AM 580 Orlando's News and Talk. We will be back next Sunday, same time, 10 a.m., and we will be discussing Florida's legal issues and how they affect you with your host and expert Moe DeWitt of the DeWitt Law Firm. Go ahead and get that question in now so we can get to it next week if we didn't have a chance to today. Just email your question to ask@dewittlaw.com. That's ask@dewittlaw.com. Or you can always call and leave a voicemail too at 407-53-MOSES. That's 407-53-MOSES. And if you need legal advice, help anytime, they're ready to help you anytime. 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. Moe, thank you once again. Another awesome show again this week. We'll talk to you next week.
Absolutely. We'll be here.
You're listening to the DeWitt Law Review on 107.3 FM and AM 580 Orlando's News and Talk.